So a case challenging the NFA and its restrictions on short-barreled rifles is now in front of the Supreme Court. But once again, the Trump DOJ is arguing in favor of the NFA, and they argue that the Supreme Court should deny review to this case. So let's talk about what is happening currently in this critical challenge. Now, before we jump into this video, if you guys want to support the channel, one of the best ways to do that is to simply subscribe to the channel. Also, double check to make sure YouTube has not unsubscribed you, because they love to do that, especially on Second Amendment channels. And I also want to thank one of the main supporters of this channel, which is 1st Phorm. You guys know that 1st Phorm is an amazing company. They have great supplements. I use their protein powder and their pre-workout all the time. I also enjoy their energy drinks. But one of the really cool things about them is their culture is unmatched. They're pro-freedom, pro-America. They support the Second Amendment and what we talk about here on the channel. So if you're interested, check them out using the links down below. And if you order something $100 or more, you can get free shipping on that order. And also they have a money back guarantee. As I mentioned in the intro, in this video, we're going to be talking about another important NFA/SBR challenge that's currently in front of the Supreme Court. This case is called U.S. versus Robinson, and it's a challenge to the NFA and its SBR restrictions. In this petition, the plaintiff asked for the Supreme Court to find that the NFA's restrictions are unconstitutional under the Second Amendment as they apply to SBRs. This is a case that was ruled on by the 11th Circuit Court of Appeals, and in that ruling, the court found that the NFA does not violate the Second Amendment. This has now prompted Mr. Robinson to seek Supreme Court review on that ruling, and the Trump DOJ recently filed their response in this case, and once again, they argue that the NFA is constitutional under the Second Amendment, and also that it's a constitutional tax on this type of restriction. Now, this is the second time in just a month that the Trump DOJ has argued in favor of the NFA and has pushed back against this type of SBR restriction in front of the Supreme Court. They are pushing for the Supreme Court to deny review to these types of cases. So we need to talk about what is happening and currently how the petitioner, how the plaintiff in this case, is responding and pushing back against the Trump DOJ. Now, the facts around this case are interesting. Essentially, back in 2022, law enforcement officers responded to a call and a complaint that there was a suspicious vehicle that was parked outside of a home. This happened, I believe, in Florida. Now, when the officers arrived, they observed that Mr. Robinson was in his vehicle, that he was asleep, and they also looked into the window and they saw what they believed to be a buttstock of a rifle. The officers flashed their lights, woke up Mr. Robinson, and he responded by trying to drive away. Eventually, he was stopped, arrested. They searched the vehicle and found an SBR in the vehicle, and also they found a separate upper for that rifle. And so he was charged with violating the NFA, and after a bench trial, he was found guilty, and then they imposed a sentence of 18 months probation and then 6 months of house arrest. Now, because of that, Mr. Robinson appealed the conviction up to the 11th Circuit Court of Appeals, and on appeal, he argued that the statute and his conviction violates the Second Amendment in light of Bruin. And he also argued that the NFA is an unconstitutional tax, and it's an unconstitutional tax on the exercise of a constitutional right, and he believes that it exceeds Congress's powers under the 10th Amendment. However, on review, like I mentioned, the 11th Circuit rejected all of those arguments. Well, now that ruling is up for review in the Supreme Court. And in the petition, there are two questions that are presented to the court to consider. First, whether the federal criminal punishment of the possession of an unregistered short-barreled rifle violates the Second Amendment. And second, whether the federal criminal punishment of the possession of an unregistered short-barreled rifle exceeds Congress's powers to tax these types of items under Article 1, Section 8, Clause 1 of the Constitution. Now, originally in this case, the government waived their right to respond to the petition, but they were actually ordered to file a response by the Supreme Court. And in that response, recently filed by the Trump DOJ, they continue to argue that the NFA and its restrictions on SBRs do not violate the Second Amendment. Now, in that brief, the Trump administration argues that there is no meaningful distinction or difference between short-barreled shotguns, which were addressed and ruled on in Miller, versus, the short-barreled rifles that are issued in this case. They argue that Miller still stands as valid precedent and is controlling on this case and this issue, and therefore the Supreme Court should simply deny review to this case. They also state that Robinson's argument that these weapons are now in common use lacks evidence, and they argue that these SBRs remain, only used by criminals, that they are not typically possessed for lawful purposes, and therefore they're dangerous and unusual items. They also argue that the NFA is a special tax that is consistent with the nation's history and tradition. They argue that there are 19th century laws which place taxes on dangerous and unusual weapons, and that these types of items are susceptible for criminal misuse. They point to taxes on weapons like dueling pistols, sword canes, Bowie knives, and other items, and they use those as justifications for why the NFA's taxation and registration process are still valid. But now the petitioner here, Mr. Robinson, in this case has filed his reply brief, and he's pushing back against those arguments that were made by the Trump DOJ. And he's using these to actually argue that the Supreme Court should grant review to this critical NFA/SBR challenge. In the reply brief, Robinson argues that the NFA violates both the Second Amendment and Congress's taxing powers. Robinson contends that the Miller case actually supports his position, not the government's position. And he argues that's because it recognized protection for arms in common use, which now he argues that that includes SBRs. He points out that SBRs are standard issue military weapons now, and they're far more common, than short-barreled shotguns that they were at that time when Miller was considered. And they've even expanded in ownership. These SBRs have expanded in ownership among civilians essentially since 2011. So there's been a big boom in people purchasing and using SBRs, and he says that that shows they're clearly in common use. Now, when it comes to the taxing power issue, the whole tax that is put in place by the NFA, Robinson says that the precedent does not save the NFA because prior cases only upheld an actual dealer tax, not this intrusive, regulatory scheme that's imposed on every single gun owner and every single item that's regulated by the NFA. He also points out that there are huge, extensive burdens that are placed on individuals like fingerprinting, registration, ATF permission to travel, and then also severe criminal penalties. And he points to all of those as proof that the NFA's $200 fee actually functions as a penalty, not just a simple tax. Robinson argues that the NFA was designed to suppress conduct, not to raise revenue like the government here is claiming. And he says if that was true, then the DOJ would not be the ones enforcing the law. It would simply be the IRS collecting taxes. He closes by urging that the Supreme Court needs to grant review to this case and strike down the NFA's restrictions on SBRs and find that they're unconstitutional both under the Second Amendment and then also the taxing clause. So this is now the second NFA and SBR, Second Amendment challenge that has been sent to the Supreme Court and is being considered by the court. This is also the second time that the Trump administration in recent history has argued in favor of the NFA and claimed that it does not violate the Second Amendment. So once again, the Trump administration has argued for the Supreme Court to deny review to the NFA and SBR challenge. It's unfortunate that that is the position that they have taken when it comes to the NFA, and that's unfortunate, that they're arguing that the Supreme Court should deny review to these cases. So this will now head to Supreme Court conference, and then we will ultimately see how does the Supreme Court want to handle this issue? How do they intend to handle this? Are they simply going to agree with the Trump DOJ and punt this case? And, that's probably likely. I would say that if the Supreme Court is going to address this, maybe they want to address a rifle ban, a state rifle ban issue first, overview and do a review of arms bans before they deal with NFA items. But you never know what the Supreme Court will do. They do a lot of surprising things. Sometimes they have more interest in some cases. Maybe they have an interest in this because it deals with a tax and the taxing powers. So we'll have to wait and see how the Supreme Court wants to handle this after conference. So as this develops, as we get more information, I will let you guys know. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. Also, you can check out one of these videos here on the screen that the YouTube algorithm thinks that you will find helpful and educational. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.